Mr. Apple stabbed his grandmother multiple times, in fact, embedded an ice pick into her skull.
Mr. Apple is not typical criminal defendant. He had no criminal history whatsoever. Mr. Apple was clearly not in a good state of mind, hearing voices, manic. The victim in the case wishes for Gage Apple to get mental health treatment rather than a prison sentence.
The version of Gage present that day was not my grandson. Now it's time for our family to heal.
I'll never be able to forgive myself. I just want to hug you.
Today, we're in Butler County, Kansas for a very disturbing case where the defendant apparently had a break with reality and buried an ice pick in his grandmother's skull. The grandmother testifies and makes an impassioned plea for her grandson, the defendant, to get the treatment he needs rather than the prison time he has earned. What's Judge Ricke gonna come up with? Let's roll, nerds.
Gage Apple appears from a Zoom location at the Butler County Detention Facility. This matter comes before the court at this time for sentencing. Court's docket notes indicate that on January 21 of 2025, Mr. Apple appeared before this court and pled no contest to an amended count 1, aggravated battery, a level 4 person felony, and count 2, aggravated assault, a level 7 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a completed pre-sentence report compiled by pre-sentence investigator Ryan Smith, who is present on this meeting with us. I trust each attorney has received a copy of the report, and I'll ask the state if they have any objection to the criminal history as stated therein.
No objection, Your Honor.
And I trust no objection by the defense, Mr. Pate?
No objection, Your Honor, and I did discuss that with Mr. Apple prior to today.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Court will ask at this time, Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Apple case this afternoon?
I know of none, Your Honor.
Mr. Pate, are you aware of any such legal reason?
I know of no reason, Your Honor.
Mr. Apple, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
Court will proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed by the defense in this case. Court is familiar with its contents. Mr. Pate, you may proceed further in regards to that motion for a departure sentence.
Thank you, Your Honor. In this case, obviously our recommendation would be that the court grant a dispositional departure and place Mr. Apple on community corrections probation for a period of 36 months. I've really stated out all the reasons for that in the motion. I did also, prior to this hearing, submit to the court a letter from the Butler County Jail from the Getting Ahead class showing programming that Mr. Apple had participated in. I submitted a psychological evaluation to the court dated December 26, 2024 that Dr. Jared Steffen completed. And I also sent a letter from Cynthia Suter, who is Mr. Apple's grandmother, dated February 25th, written in support of him. She's a retired circuit judge from Missouri. I would also, as I'm sure the court and counsel has seen, just direct everyone's attention to the letter that one of the victims, Patricia Apple, wrote that's also attached to the pre-sentence investigation. I think that the biggest thing here, and I think Dr. Steffen does a really good job of setting it out in his evaluation. Mr. Apple is not, I guess, the typical criminal defendant that we see, especially in a violent person crime type of situation. He was 30 when this happened. He had no criminal history whatsoever. He does have some pretty serious mental health issues. He's been diagnosed with bipolar disorder. I think if you review the affidavit in this case and you review the evaluation, Mr. Apple was clearly not in a good state of mind when this occurred. I think he was hearing voices. Specifically, Dr. Stephan noted that his psychotic and manic mental state adversely affected his abilities to perceive, judge, reason, and control his behavior in a rational manner. Mr. Apple was experiencing extreme mental and emotional disturbances that substantially impaired his capacity for judgment and to conform his conduct to the requirements of law. That is one of the non-exclusive departure factors that's specifically set forth in KSA 216815. I think it's important to note Dr. Stephan did not have the opinion, and we are not arguing that this is a mental disease or defect case where Mr. Apple did not have the ability to understand the difference between right or wrong. We're not making that statement. The report does not establish that. I think Mr. Apple understands and understood the criminality of his conduct. I think he was just in such a bad mental state that it made it difficult to conform his conduct to the requirements of law. So I think that's supportive of the specifically enumerated departure factor. As I said, he's also engaged in programming in the Butler County Jail. He completed the Getting Ahead While Getting Out class, which was a 10-week program. Ms. Apple, the victim in the case, wishes for Gage Apple to get mental health treatment rather than a prison sentence. I don't think Mr. Apple is an inherently bad or dangerous or violent person. I think he's an individual with severe mental health issues that is going to need treatment, and he's going to need medication, and that's going to exist whether he gets probation today or whether he goes to prison for several years and gets out and he's on post release. He's going to need that to be successful. I think given his mental state, I think he's probably going to be subject to manipulation and victimization in prison as well, more than the typical inmate. I know Mr. Apple has indicated to me that he wants to get back in programming with South Central Mental Health. He's willing to follow the recommendations that Dr. Stephan has set forth, which include completing an anger management program and domestic violence treatment program, and also to engage in substance abuse treatment. Mr. Apple does have a history of some substance abuse, and like we often see, I think when you combine the substance abuse and the mental health, it exacerbates those issues, it complicates them. So it's going to be absolutely critical that he stay sober and get the treatment necessary to do that. I would note to that end, he's served 236 days in jail, so almost 8 months. That's, number one, been a substantial sanction and restriction on his freedom, especially for a person that is 30 years old and doesn't have any criminal history. It's also been a substantial period of forced sobriety. And I think rather than just sitting there and twiddling his thumbs, I think he's been trying to do everything he can to better himself, so when he does get out, he would be successful. So for those reasons, Your Honor, we're asking the court consider imposing probation. If the court does that and wants to give Mr. Apple a lengthy underlying sentence, I think that would be appropriate and understandable. If for some reason the court does not grant probation, our formal request would be for counts 1 and 2 to run concurrent, and the court to also consider a durational departure. But as I said, our primary request is a dispositional departure, and if the court grants that, we think whatever underlying sentence the court deems appropriate is acceptable to the defense.
Page, several questions arise. Let's look at it first from a question of statutory authority. This is a presumptive prison case. What mental health confined facility exists that this court has the authority to make a direct placement into?
I don't necessarily think there's a confined facility that's available to him immediately, I think if he did have one available, I think the court could order him to do that as a condition of his probation. I'm not aware that there's a bed waiting for him, and that wasn't necessarily our request that he be sent to a confined mental health facility. We were thinking more along the lines of medication management, getting back in with South Central Mental Health, going to therapy, taking substance abuse treatment, and things of those nature. But I do think if there was a confined mental health facility available and he was ordered to complete that as a condition of probation, I think he would be more than willing to do that. I think that would be much more beneficial to Mr. Apple than prison for a number of reasons that I've already stated.
And how would this court be assured that there is such a facility that would accept Mr. Apple?
I don't
If I
think
can't
there's
make a
any.
direct placement, then how am I assured that he will ever go to such facility?
Well, I think he would have to make application to such a facility. I think in that case, the court could order up to a 60-day jail sanction prospectively from today to allow time for that to take place. And then once a bed is available, grant parole from those 60 days or allow him to go just simply at the expiration of 60 days.
All right. I'm also concerned here, Mr. Pate. Obviously, the underlying facts of this case is that Mr. Apple stabbed his grandmother multiple times in the face and head area. In fact, embedded an ice pick into her skull at one point. An extremely violent offense in which the victim herself called evil. This court agrees. So how does your plan, which is essentially a release Mr. Apple into the community, how does that protect society, Mr. Pate?
Your Honor, if he's maintaining sobriety, if he's engaging in treatment, if he's following recommended medication management, I think those safeguards would ensure community safety. I think from what I see, his actions here were a product of a severe mental disturbance. I think you look at an individual who's 30 years of age, he has no prior criminal history at all. Usually in the typical violent person felony case that I see, you usually see a long criminal history where a person has escalated from minor drug offenses, property offenses on up, and then they graduate up to really serious things like this. I would say in my experience, it's a very, very, very rare case where you see a person that's 30 years of age with a clean record that just starts off with an aggravated battery that was originally charged as an attempted murder, unless that's a crime of passion or something like that, which this isn't. I think it was a product of Mr. Apple hallucinating, hearing voices and things of that nature. So I think his history would dictate, if we're managing the mental health thing of this very, very closely, that he's not a person that's likely to commit repeat violent offenses.
Very well, Mr. Pate. Mr. Sweeney, what is the state's position regarding this departure request?
Your Honor, the state stands in opposition of the departure request. I'm in receipt of all of the documentation that Mr. Pate has referenced regarding Dr. Steffen's reports. And I don't deny, or I don't take issue with the fact that he may and probably did have some mental health issues going on at the time, maybe exacerbated by some drug usage. But that's something that we see in a lot of defendants that come through this court and other courts. And it doesn't absolve them or at least it shouldn't, from an appropriate punishment. And given the incredibly violent, brutal nature, the courts addressed what the facts of this case were. An ice pick that was used to attack his grandmother on or about her face and in her head. It's incredibly violent, and I would note and acknowledge, because I've seen the documentation from Miss Apple, and we've had contact with Miss Patricia Apple, that she wants a probationary or rehabilitative order from this court. And you know, I can certainly appreciate that as his grandma. She loves her grandson, but I have to look at the public safety at large, and just given the incredibly violent nature of this offense, I don't think public safety is benefited if he's given a non-prison sentence. So the state would be asking for the prison sentence to be imposed, and we stand in opposition to dispositional and or durational departure.
I understand the state's position, Mr. Sweeney. Mr. Pate, anything further regarding your request for a departure sentence? I will be asking you for formal recommendations later, but anything else on the departure?
Not as to the departure, Your Honor.
Very well. Thank you. The court will ask at this time then, are there any victims present who desire to address the court in relation to this sentencing? Patricia, do you wish to address the court?
Yes, I do.
All right, you may make your statement at this time.
I want to start by thanking you, Judge Ricke, for giving me the opportunity to speak and for the professional manner in which you've handled the difficult aspect of this case. But also the respect you've shown Gage throughout. Those who have known Gage for over the years would never have believed him capable of doing what he did on July 24th, 1924. It was a shock to everyone. Gage has always showed me nothing but love and respect. If it wasn't for mental health reasons, I know in my heart we wouldn't be here today. The version of Gage present that day was not my grandson. The look in his eyes were the most completely lost, and it seemed as if he didn't even know who I was. For 30 years, Gage has been nothing but good to me, and breaks my heart that he couldn't get the sufficient help he needed through the attempts, even though he had made attempts with Butler County Mental Health. I'm sharing this in hopes that you will consider giving him concurrent sentence so that Gage will be one step closer to getting proper help he needs. I also ask that the contact with me won't be restricted anymore. For having the family support through the time is very important. I do also want to take a moment to make it known how proud I am of my two youngest grandsons who were outside of the house during the incident. It weighs heavy on my heart for what the boys went through that day, and forever be thankful for the help that my two little heroes got me. Now it's time for our family to heal, and I just pray you do the right thing for Gage. Thank you for listening.
Thank you for your statement, Ms. Apple. Finding no other persons to address the court in relation to this sentencing in the nature of victims or victims' family members, court noting the court has received some written document submissions that have been referred to earlier, which the court has and will consider. The court at this time will ask counsel for their formal recommendations regarding an appropriate sentence for Mr. Apple, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, with respect to count one, the state would recommend the standard and mid-box 41 months and DOC. With respect to count two, the state would recommend the standard and mid-box 12 months and DOC. We would acknowledge he does have 236 days of jail time credit. He would have a 15% maximum good time percentage on count number one, as well as 20% on count number two. He would have a post-release supervision duration of 36 months. on count number 1. Your Honor, pursuant to the plea agreement, we're not seeking any fine in this case. We are, of course, seeking the court costs, attorneys and bids fees if the court would find appropriate. And this is a first-time felony, so the state's seeking a DNA fee. This is, of course, a registration offense. I know he's been in custody, but I do think that needs to be addressed. As far as, no contact with the victim, his grandmother, obviously the state's asking for prison. I don't know that the state would have, I mean, if he's being sent to prison, I guess that's kind of out of the court's hands. But I don't know that the state would have any objection to him having contact with her inside the confines of Kansas Department of Corrections. Given the nature of the plea agreement, I don't think I have any further recommendations.
Very well. Thank you, Mr. Sweeney. Mr. Pate, your formal recommendations regarding an appropriate sentence.
Your Honor, our primary recommendation would be the court grant the departure, place Mr. Apple on community corrections for a period of 36 months, with 15% good time on count 1, 20% good time on count 2 if prison is imposed, and then 36 months of post-release. We agree he would be entitled to 236 days of jail credit. In the event the court grants the departure, we would leave the underlying sentence to the discretion of the court, whether the court thought concurrent or consecutive was appropriate. In the event that the court thinks prison is appropriate, we would ask the court to consider a durational departure to an appropriate sentence less than the mitigated number of 38 months on count 1, with count 2 to run concurrent. In the event the court does not think a durational departure is appropriate, we would ask for 38 months on count 1, with count 2 to run concurrent with a 12-month sentence, I suppose. I think I already said it. In that case, there'd be 15% good time count 1, 20% good time count 2, and then 36 months of post-release.
And your fees in the representation of this client, Mr. Pate?
They're approximately $2,200, so I think that's at a level where I'm going to have to ask for an exceptional order.
Very well. Understood, Mr. Pate. You've articulated your position and the position of your client well, Mr. Pate. I'll now turn to Mr. Apple himself, and I'll ask the defendant if he has any statements that he wishes to make on his own behalf in mitigation of punishment, or Mr. Apple, anything else that you wish to present to the court?
Yes, sir. If you don't mind.
Okay.
Okay. Bear with me. The first one that I have, if it's okay, I want to start out with an apology to my grandma. I know everyone knows her as my Nana, but I just wanted to say this to you. This is from my Nana, Patty Apple, and anyone else affected in this case. I am so sorry that there aren't words to describe how truly sorry I am. I pray for you all day and every day. This trauma has changed our lives forever, but I hope you can forgive me one day. I'll never be able to forgive myself. I'm haunted by this event every day forever. You are my best friend, someone who I can talk to and share memories with. You've raised me, and I would never imagine causing you or anyone any harm. That day I felt a huge part of myself died. The anger took over and I felt I was a little possessed. I'm not sure how, but I want a life, a chance at life. And I'll do whatever it takes to have another chance. God, I need you now more than ever. My deepest apologies. God bless you, and I hope you are well, Nana. And then I just wanted to read this for the courts. Thank you, Your Honor, for hearing me out and allowing me to say a few things on my own behalf. Growing up, I found myself associated with people who exhibited some unhealthy negative behaviors that led to my own struggles in my own life and my mental health. In 2018, I sought out a way to get off the alcohol in an attempt to break the chains of my addiction. I started seeing a med provider on a monthly basis where I was ultimately diagnosed with anxiety, depression, the major depressive disorder, bipolar, mania, meds for PTSD. This gave me perspective on how much I needed treatment. Living all my life up to that point undiagnosed made me aware of how much this has affected my own life as well as those around me. My clean date from my drug of choice is June 21st, 2018. In jail, I have participated in the AA groups, the Thrive reentry class, and Bible study on a weekly basis. I've put together some contact information for Oxford houses and halfway houses, as well as jobs in the area that hire people with a record. Wichita workforce, temp agencies, and support groups. Upon release, I plan to work ASAP and open to school to better myself for the future. I have some previous employers that I will reapply for, such as Walmart and Sam's Club. Within the first 3 months of being released, I will have ordered a driver's license and other documents to help me get a job. Once I know more about a sentencing and potential release date, I can reach out to all of these resources listed above, which would include like bed dates at the Oxford houses and what their immediate availability would be to have me move in as a tenant. Thank you for hearing me out once more. And I do want to state that since I've been here at the jail, I have continued to make my medical lady down here, the nurse down here, she has been in constant dealings with my doctor at South Central Mental Health. She's the one who advocated to get me put back on the medications and stuff like that. And, after last year, I was weaning off and then getting back on the medications. Then I ended up in the hospital for 15 days in their psych unit. And, that was because I was getting off the meds. Thankfully, I've been able to get back on those meds and have them monitored by psychiatrists in Wichita. I don't know all the list of the names, but I see someone, first it was on a weekly basis, sometimes more than once, but still up to this point on a regular basis. The only thing that I could think of would be Good Shepherd, but that's not really a place that's going to do anything more than, I've been there a few times before for like detox and getting put on medications. But long term, since I have all the medications and stuff that I was on prior to, I'm back and I've been stabilized. When I got to the jail here, I weighed 106 pounds. They immediately put me on 24-hour watch because my body mass index was so low. And since then, I weighed in a couple of days ago, this last week, I weighed in 143 pounds. I've never been this healthy in my life. And the support that I have here at the jail has been astounding. So I just wanted to say thank you for hearing me out. And I just wanted to say, because I haven't seen her face, I am so sorry and I love you so much. I just want to hug you. I just want to hug you. Because tomorrow was never promised and I hate this. Oh, I'm supposed to be home with you, taking care of you. And I'm so sorry to you and I'm so sorry to the boys. It's just an awful thing. So I'm so glad you were able to be here. Anyways, I hope you're safe. I hope you're well. I hope with all the good things. And I know that I don't have any words. Nana, you don't deserve this from me or anyone. And I'm so sorry. I am so, so sorry.
All right, Mr. Apple. The court's ready to pronounce sentence in your case. The court's giving you some latitude at the end of your statement to make some statements of apology to Patricia Apple, your grandmother, which she's certainly entitled to under the circumstances of this case, and I'll give you a certain amount of credit for doing so. Mr. Apple, I tend to agree with what Patricia once labeled your acts as, and that is evil. Somewhere there was an evil in you that was unleashed that day that caused you to take an ice pick and try to stick it through your grandmother's eyes and lodge that ice pick into her head after multiple stab wounds. That is not threatened harm. That is very, very serious actual harm that was done to another human being, especially one that you had every reason to love. What a sweet lady she is. To come to court and advocate for you after what you did to her. What a wonderful woman. She deserved better than the treatment you gave her that day. The court has to judge your actions here. And I will say, Mr. Apple, after everything's been presented, and I've read everything that's been presented to the court, that the court wishes to show you mercy. The court wishes to show you compassion. This court also has to weigh, however, your threat to society, which the court considers to be considerable, even as we speak. The court will go ahead and start pronouncing its sentence at this time. The court hereby establishes count 1 as the base sentence in this case for the offense of aggravated battery, a severity level 4, non-drug person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 4I. The court hereby sentences the defendant to a term of 38 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed. Regarding count 2, for the additional offense of aggravated assault committed with a deadly weapon, based on court finding that the ice pick used in this case was a deadly weapon, the court finds that this is a severity level 7, non-drug person felony. The court imposes 12 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant is eligible to receive 20% of good time credit and would be subject to 12 months post-release supervision on that charge and charge alone. However, the court will at this time run the counts and the time on counts 1 and 2 concurrently with one another. So there is a controlling sentence in this case of 38 months. Mr. Apple, your attorney, as I stated earlier, and sorry about the loss of video, that was unintended. Your attorney's argued well on your behalf for a departure. I do note all of the statements in support, including your grandmother, Patricia. However, this court, despite its wanting to show you mercy and compassion, also has to look, as I stated earlier, on the protection of society. For this probation plan that Mr. Pate argues for today to work, a lot of voluntary things would have to take place where this court would have to count on your willingness and consistency in performing those things. There are issues about where you would live, where you would work, what kind of treatment program you'd be in, and whether you would voluntarily participate in a long-term mental health treatment program and take the medications that have been prescribed, especially with your long history of substance abuse. These all, in this court's view, create problems with any probation program that might be established. This court is bothered tremendously, Mr. Apple, and this is not necessarily your fault, that the Department of Corrections does not have a facility that is centered solely on mental health treatment in a confined setting. You would be a poster child for placement in such a facility. But no such facility exists. What we have is a correctional system, a prison system, or you're out in the community. And this court has to resolve today which of those two is better in this case. The court makes the ultimate determination that there are no substantial and compelling reasons for this court to grant a dispositional departure in this case. The legislature has determined that someone in your grid box who's committed a level 4 serious felony crime is to be presumptive prison. There's not enough here to overturn that statutory presumption. And the court finds that the court will deny the request for a dispositional departure in this case. This court has granted the minimum sentence under the Kansas guidelines for sentencing in this case. I've run the counts concurrently with one another, and I've granted you the mitigated sentence in this case of 38 months, and also noting that you've already served 236 days, about 8 months of that sentence, and you do have the eligibility to earn good time credit toward that sentence. So it's not going to be a very long prison sentence, Mr. Apple, but this court is going to follow the statutory presumption in this case and order you to serve your time in prison. And that is a controlling sentence of 38 months. I don't think there's a request here for restitution to the victim, Mr. Sweeney.
That's accurate, Your Honor.
All right. Of course, already dealt with the issue of jail time credit. The court awards 236 days, I think, is the proper computation as of today. And the sentencing journal entry should reflect the 236 days jail time credit. I will remind Mr. Apple of his obligation to register as a violent offender for a period of 15 years under the Kansas Offender Registration Act, dealing with periods where you are not incarcerated. I'll advise you, Mr. Apple, that you someday may have the right to seek expungement of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant has a right to appeal their convictions to an appellate court having jurisdiction. And if such defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Apple, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. Mr. Apple, I'll remind you that there's prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. The court will be assessing a felony docket fee in this case, and I think it's still appropriate for this court to assess to the defendant a $200 DNA fee. The court will waive bids, amounts, and all other costs given the court's prison order that it's made here today. Mr. Sweeney, I'm looking at my notes from this sentencing proceeding. Are you aware of any other sentencing related matter that the court still needs to address or readdress?
No, Your Honor.
Mr. Pate, are you aware of a sentencing related matter that the court has not yet addressed?
Is the court also considering and denying any request for a durational departure?
That was implicit in the court's announcement of its sentence, Mr. Pate. The court has denied a durational departure in this case.
Thank you.
All right. With all of that said, Mr. Apple, I do see in you a current willingness to take advantage of any programming that's available to you to get yourself better. I highly suggest that you continue to do that. First of all, that type of participation in programming in Department of Corrections custody will help you earn those good time credits against your sentence for an earlier release date. Furthermore, I would like to think that you're going to be in the best possible shape when you're released back into the community, so something like this never, ever happens again. Good luck in that regard, Mr. Apple. I hope you're successful in participating and doing well in those programs.
Thank you, Your Honor.
All right. Patricia Apple, I do appreciate your appearance here today and your addressing the court. Good luck to you in the future, ma'am. All right. If there's nothing further, then Mr. Apple will remain in the custody of the Butler County Sheriff's representatives until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 38-month prison sentence that's been imposed here today. There's nothing further. The Gage Apple matter will currently be in recess.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.